That's one thing that I heard. The second thing that I heard, and I'm going to try and not use my fancy volume words. Presently, you have, correct me if I'm wrong, because it sounds like Groundhog Day, you have the ability to go into that trial court judge and say, we have an issue on coverage, Judge. Can we have a declaratory judgment on a coverage issue? Do we have that ability to do that?
No, that's not true.
That's what we don't have. That's why there's legislation the last couple of years.
One of the changes allows the insurance carrier to intervene in the case. You cannot do that. The courts have held that if you have a coverage issue, you can't, the insurance company cannot intervene in the underlying tort case to get a stay to then determine the coverage issue. That would frankly make a lot of sense. But right now you cannot do that. And that's part of the problem.
And I'm, again, and feeling like Groundhog Day, it's, I don't recall when this statute was written, but it's kind of like a lot of the other things we do around here. There was a good reason and we all forgot why. And it was a bad idea to change 20 years ago, and it's a bad idea today. So I hope some of our other people here will remind me why this, aside from what we've discussed, what I think is a good law. But thank you, Mr. Chairman. Thank you.
Any other questions for these witnesses? Representative Waldrop?
Thank you, Mr. Chairman. To inquire.
Proceed.
Thank you. In theory, would this speed up the claims process for a carrier?
I don't think it would delay it. I think it could speed it up. I mean, I don't know why it would delay it. This happens not in a small minority of cases. Most cases that we defend, let's say it's an auto accident, there's not a coverage issue, you go defend it.
We're talking more about broad form product liability. We're talking about broad form use of a company car. We're talking about completed products and operations, these sort of large suits that would involve a business.
Well, as you'll note in the legislation, there is a 60-day window, I think, once you have knowledge of certain information to make a decision. So it can't be delayed. The idea is, but you have to have an opportunity to have the appropriate information. Once you get it, you have 60 days to make a decision to defend with reservation of rights or what your decision is going to be. I think that's a reasonable period of time.
Just thinking through my experience, I'm a recovering insurance agent, and I remember often we would have the coverage team, when we had a situation like this, permissive use on the personal line side is a big deal, but you'd have the coverage team review the policy, and it may be several weeks before you got any word, and then you would get a reserve letter, right? So my agency would get a reserve letter. Chris, we've charged you $100,000 while we're working through the claim between party A and party B, and it just seems to me that maybe a carrier could speed up the process to speed up the the process of making a client whole. If you could, I'm just thinking through this, have a reservation of rights where you could, with some confidence, assign this to your claims team, knowing that if the information changes, if there's an outlier, a witness, a police report, an extenuating circumstance, you still have some ability to recover some of that. Because once my carrier set a reserve on the agency, we were pretty well convinced that whatever that reserve was going to be our claim, if not more.
Well, this gives the opportunity to go through the claims process and make the right decisions. You're not being pushed into it.
You said Missouri is an outlier. How many states do it our way? How many states do it your way?
Well, I'm not, Dale, are you aware of any state that has, I'm not aware of any state, but that doesn't mean that may be done in Rhode Island that way, but not around here, it might not.
I'm not aware of another state that permits the policyholder to say, no, I will not accept a defense with a reservation of rights. I'm not telling you there isn't one, but I'm not aware of it.
Last technical question. Some of the policies we were selling over the last few years, carriers were giving options to include defense coverage in the limit or exclude defense coverage in the limit. Obviously that changes the premium. Is there a scenario, does either one of those scenarios play into this legislation at all?
There's no, I don't think the legislation distinguishes between those two. If there's a duty to defend, the legislation is triggered. That's really the trigger. It doesn't matter whether it's in the limit or out.
Very good. Thank you for your time.
Representative Hansen.
To inquire.
Proceed.
So just to be clear, you use Kansas as an example, but I think Representative asked, so all the states that surround Missouri,
As far as I know.
as far as you know, Illinois, Arkansas, Iowa, We're the only one left standing?
It's an unusual situation in Missouri.
It is, and I've had the same experience Mike has of people calling me up and saying, what's this about the ability, some rule in Missouri that the insured doesn't have to accept a reservation of rights, they can reject it, because people who work nationally are stunned by it the first time they come in contact with it.
All right, is there any other questions for these witnesses? Seeing none. Anyone else here to testify in favor of House Bill 1344?
I filled out a form.
Thank you.